Hello, everyone, and thank you for joining us here today. My name is Gene Quinn. We appreciate you spending a portion of your day with us here to talk about PTAB matters. We're going to get going here momentarily. We'll let everybody get in from the ready room into the Zoom room here. And that gives me an opportunity to thank our sponsors. We could not possibly do what we do without the cooperation and support of our sponsors. And we have a number of great PTAB sponsors here this year, probably, I think, more than we've had in the past. There's a lot of interest in the topic. We had almost 700 of you register to be a part of this virtual broadcast. Those of you who need CLE will be getting CLE. We have a list somewhere that can be provided for you in the chat. I think it's linked on the page on IP Watchdog that explains the states where we have applied and also the states that have reciprocity with where it is that we have applied. And I think we've got just about everybody covered here. So again, I appreciate you being here today with us. Oh, my video kind of froze. Sorry about that. And thank you to our sponsors. So I'm not going to be moderating this panel. I will be here listening and maybe chatting with you as this is all going on. But I'm going to kick it over to Renee to introduce your moderator and your panelists. So Renee.
Yeah, thank you, Gene. All right, so our moderator today is Todd Walters. He's a shareholder at Buchanan, Ingersoll, and Rooney, where he chairs the firm's patent office litigation practice and co-chairs its IP section. A nationally recognized PTAB leader, Todd has handled over 100 post-grant proceedings across technologies and is consistently ranked among the top patent litigators in the country. He's widely known for his deep PTAB experience and practical strategic insight. On the panel, we have Chief Judge Scott Bullock. He leads the Patent Trial and Appeal Board, overseeing all post-grant trials and patent appeals. Since joining the board in 2007, he has served in nearly every judicial leadership role. With experience spanning government service, private practice, and engineering, Chief Bullock offers a comprehensive perspective on PTAB practice and policy. Next, we have the Honorable Michael Tierney. He is Vice Chief Judge of the Patent Trial and Appeals Board and has served on the board since 2000. He played a leading role in implementing the AIA Act and developing the PTAB's trial rules. With experience as both a patent examiner and private practitioner, Judge Tierney brings decades of institutional and technical expertise to PTAB practice. Next, we have Terry Ray. She's a leading authority on patent practice and IP strategy and a former acting director of the USPTO. She is a past president of AIPLA and the National Inventors Hall of Fame and has advised innovators, policymakers, and institutions across the globe. Terry is widely recognized as one of the most influential figures in modern intellectual property law. And last but not least, we have Jackie Wright Bonilla. She's a director at Stern Kessler and a former deputy chief administrative patent judge at the PTAB. She presides over hundreds of AIA trials and helped shape PTAB policy and operation. With a PhD in pharmacology, Jackie brings rare scientific depth and leadership experience to complex life sciences and post-grant matters. So this is an amazing panel. Back to you, Gene.
Great. Thanks a lot, Renee. And again, thank you for all being here. I'm going to just exit stage left here and turn it over to our moderator, Todd Walters. Todd, take it away.
Thanks, Gene. I want to thank Gene and Renee for setting up this program because we really have a who's who of panelists here. We're going to talk about the evolving PTAB landscape and inside efforts to recalibrate that landscape. It's one of those things that we've seen over the years, and I've been practicing for the PTAB for over 30 years. We see changes from time to time, and there's a lot of history behind the PTAB. And we built the PTAB up to a very large number of people after AIA was enacted. And I'd like to start off with the panel and talk about the history of the PTAB and the model for building that 250 plus lawyer group that handled AIA trials. Mike, can you start off?
Sure. And basically, there's a huge topic here. We could spend an entire day going back on the history of the board because for anyone who's interested in history of the board, there's a great website, AAPJ, Association of Administrative Patent Judges.us. They have a full slide set, can walk you through the full history. Key thing, Lincoln, who himself was a patent holder, basically had the first three examiners in chief back in 1861. Going fast forward, we'll talk about 2011, how it already going from a BPAI to the PTAB. And as you remember, it was a very big time of change and put the pieces in play. You had Kapos, who's from IBM, Terry, who is, as you know, law firm plus AIPLA president. You had James Smith, who was former Federal Circuit clerk, law firm, corporate law. And James was extremely bright and a perfectionist, just putting that aside. You had Ray Chen, solicitor, who's now Federal Circuit judge. You had all these pieces in play. And Kapos, for what it's worth, he wanted us to make a running start. He was not going to wait to see if the law passed. He was confident about it. He basically had us looking at January 2011. What is this law going to do and how is it going to impact us? And the key thing here is it wasn't just the board. Remember, it was first inventor to file to first inventor, first inventor, first to invent to first inventor to file. We get so used to it. But that was a big push for the AIA. We were almost a secondary with the PTAB. And one of the things that we had to do is figure out how do we want to grow? You had the legal part, you had the infrastructure part. In infrastructure, we're talking about technology. You also had, we only had about 100 judges back in 2010, 2011, and we needed to ramp up because, as many of you recall, we had a 26,000 ex parte case backlog, ex parte appeal. So we had to have a vision. So James is very good about bringing us all together and working with Dave Kapos, Terry Ray, and others. And we had interview after interview after interview. I know Scott Bullock sat in hundreds of them. Jay Moore, who you'll hear from later, was in hundreds of them. But there were some things that were very clear. And that is, we want the best and brightest legal and technical candidates we can find. But not just that, you wanted the most dedicated people. You wanted people who are going to go the extra mile. You also, the key part, and I know I'm going to turn over in a sec to others, but the key for me was collegiality. Do they play well in the sandbox with others? Because everything we do for final written decisions, for ex parte appeals, you have to work well in groups of three. So if you don't work well with others, it wasn't going to work very well to have you hired at the board. So you could have the best mind legally, technically, but if they aren't going to work well with others, it probably wouldn't be the best fit. So James, being a perfectionist, actually, I remember, and lead judge Robertson at the time, we were getting emails. And for example, I had one that was like a 2 a.m. email in the morning saying, if we were to hire people that were less than the best, how many hours would we waste on these people? And I know Terry Ray's here. Just she'll probably be able to chime in about how many hours she spent with James trying to convince him to hire more of these qualified candidates. So with that, I'm going to turn over to my colleagues.
I'll just add one thing. A lot of what you were talking about, Mike, was the buildup after 2012 when the American Invents Act passed. I think most people on this, watching us is probably pretty initiated. But for those who aren't, I think it's really important to recognize that the board is actually, in some capacity, by some name, has been around for a really long time. It's basically been around since the 1830s in some capacity. And the job of the board, relatively similar to what we do today, has been around for decades before the AIA. I mean, for example, there were interferences, there were ex parte and inter parte re-exams, the creation of PTAB, if you will, was really renaming it and then just doing some changes in its jurisdiction. For example, it did away with interferences, the AIA did, and it replaced inter partes re-exams with IPRs, and then added PGRs and what we call covered business method patents, CBMs, which have sunset since. So I just wanted to add that it's really important to understand just how long the board has been around and how long it's been doing things like adjudicating the patentability of claims. So it's just a good reminder for those who may really appreciate that.
Oh, no, and just completely, we were building upon the backs of the great work that people had done before. Like you say, for inter partes re-exam, I mean, those who practice it remember the rule sets from inter partes re-exam and just how, I'll just say, they were cumbersome, overly detailed, and at times impractical and very difficult to work with. We learned from those mistakes and we're able to create a more lightweight set of rules and put a practice guide out there that was able to basically get the nitty-gritty nuts and bolts. But at least we didn't have things like a 4173 is what we would always say, that do loop, where it's kind of like goes from from the examiner to the board, back to the examiner, back to the board, and getting kind of a ping pong, or the petition practice where people petitioned constantly and caused delays in getting inter-party re-exams done, which I think I'm correct in saying I think the last inter-party re-exam will be NERCed later this year, or just get to the final point. So even though we're 13 and some odd months out, 13 years, some odd months later than the last inter-party re-exam was filed, it's finally coming to a close.
And I have just three quick points to add on to that one. I just want to emphasize the professionalism of the board. It's always been staffed by the most experienced, patent lawyers, both in the agency and from the outside. When the AIA passed, the board more than doubled in size, reaching about 270 judges at its peak. A year ago, it was about 230. I don't know where we are now, but it's well under 200. One of the other things that happened after the AIA is that the board became a nationwide workforce. Before it was all, with the exception of Fred McKelvey, pretty much all in the Alexandria office. When the regional offices opened in Denver and Dallas, San Jose, and Detroit, and then we went to a telework model. The workforce is distributed across the country, allowing the board to hire the very best wherever they happen to be. So those are the points. I just wanted to reemphasize that the level of professionalism, it is on par with my clerkship at the Federal Circuit. Barring my clerkship, I've never had the chance to work with such a group of truly dedicated professionals who want to do the right thing, follow the law, to the best of human ability. So I'm quite proud of what the board became.
Sounds good. Scott, that was fantastic. Jackie, as usual. And Mike, it was great. I should tell you that Mike actually, that early work he did was primarily putting the practice guide together. So he really did the roadmap that to this day, to some extent, we are still following. It's been modified statutorily, but it's amazing. And Jackie was right in there as well as Scott. But I think that Tierney sent his kids to bed every night by reading proposed Federal Register notices. And I think I told you that enough times, Mike, that you remember it. Yeah. Okay. So, and then another thing to those of you on the call, you should be aware when he mentioned the American Association of Patent Judges, is that your AAPJ pin that you have on, Mike?
It is.
As the current president of AAPJ, you have put me to shame, just saying, because people on this call have noticed that. So you're not doing me any favors. But the AAPJ does have a great website that explains the history of the BPAI and the AAPJ. And the whole point, or the primary purpose of the AAPJ, is to memorialize and keep in history and clarify the history of the board, because we wanted to preserve as much as possible. And then the final point that I wanted to very quickly make before I send it back to you, Todd, for the next point, is that James Smith was amazingly picky, and that's really the best word to put. I mean, in terms of he tried to read every decision that came out in the early days. He wanted to hire the best and the brightest. The interview process, I don't have time to go into right now, but it was one of the most unusual and arduous interview processes that you've ever seen, just because we were looking for personality types and collegiality. But another thing with James Smith, and it'll segue to the erosion of talent concept, is that the PTAB got the best and the brightest. And even Dave Kapos was amazed the people who agreed to be who put their name in the hat and then once given an offer actually accepted, because typically they got significant pay cuts. So the talent that was being created at the board, I always figured you guys would defend me well. And so good. I wanted you to represent the agency and that, I wasn't going to be left on the line. So I wanted to thank the three people on this call, Judge Bullock, Judge Bonilla, and Judge Tierney for all their fantastic work. Todd?
Yeah, it didn't go unnoticed when Scott was mentioning that the PTAB was over 270 APJs and now well under 200 APJs. And that seems like a loss of talent, and it's not going unnoticed. And Jackie, maybe you can lead off on this one. What's going on?
So, in the beginning of January of 2025, we were, I think, at 230, and I think now we're the board is now between 170 and 180, somewhere in there. So there has been a loss, but I think it's important to understand the context of what's going on. I mean, there has been, you've seen a lot of changes to the federal government. This is nationwide what you've seen for loss of people and subject matter experts in agencies in the U.S. government, and this happened at the PTO as well. The changes that we talk about at PTAB, they weren't specific to PTAB. There have been big changes to the USPTO itself. And some of this has to do with the fact that we've lost a lot of people in our workforce. To be honest, the turnover at the USPTO at large has been unprecedented, and this is agency-wide, not just at PTAB. And what we saw is since February 2025, the political leadership created many incentives, both positive and negative, agency-wide. This is including at the PTAB, the TTAB, the Solicitor's Office, the CRU, the IT, HR, and all the staff to basically leave the federal government. There were a number of things in place. The first one was in the end of January last year, the deferred resignation program, what they call the fork in the road email that came to everybody. They began to remove or relocate non-probationary people that were not examiners. They incentivized early retirement and early separation incentives through something called VERA and VSIP. This started in February. In February, they also mandated return to office 5 days a week. So effectively no telework for anybody living within 50 miles, except for certain non-probationary, non-supervised examiners. And I think I think everybody understands, especially after COVID, but even well before that, that telework was a big part of working at the USPTO. Over 90% of the people who worked at the USPTO teleworked in some capacity. So this had a really big impact on people's ability to stay at the job. They may have revolved their life around the ability to work from home sometimes. Another thing that happened was RIFs. This is reduction in force, and more specifically, the threats of them. I think there was some RIFs in October. It was a relatively small number at the USPTO. I think it was less than 150 people. But it turns out the fear of RIFs has a real impact on whether people will stay at the agency. And that is something I think is still on people's minds. Another thing that's important is the loss of basically existing leadership that was in place at the very beginning of January 2025. They lost a lot all at once. I mean, the Commissioner of Patents, the Commissioner of Trademarks, these are positions that were posted as openings at the USPTO. So the commissioners, the chief judge at PTAB, I think people probably know now that both Scott Bullock and Mike Tierney have now left the office, that we lost the chief judge at TTAB, some deputy commissioners, the solicitor, the deputy solicitor, the chief administrative office, the chief financial office, the chief information officer, so on. There was just almost nearly all of the leadership positions were effectively being replaced for one reason or another, either because they were leaving on their own or what have you. Another thing that happened was all of the members of PPACT were removed in 2025. So that's another thing. So you basically did see a lot of people, and again, this is not specific to the USPTO or the PTAB, a lot of loss of subject matter experts that have helped run the agency in the past.
Anyone else want to jump in?
I think Jackie covered it pretty thoroughly there.
All right, great. Let's then turn to current operations? And Scott, you know operations as well as anybody. And what are the current operations within the PTAB, and what's the workload look like for the APJs going forward?
Right. Well, as we sort of talked about, so I won't hit it too much, but again, the current number of judges on staff is dramatically less than it was even a year ago. The filings have continued to drop and drop. About a year ago, we were getting about 120-ish IPR petitions per month. And that is down. I think the latest figure I saw, although the office appears to have stopped publishing statistics on the web around December, November, I guess it looks like maybe the last update that I could find on the web. But at least I've seen various commenters saying that they're down to about 40-ish, which for reasons that I'm sure we'll be getting into shortly, it makes sense that it dropped off a cliff, which was quite the intent. And they've done a great job of driving filings, down to a very low level. PGR filings were never much of a factor. They were 5 to 10 a month. And all of the efforts that we did over all the years to bring those up never really moved the needle. On appeals, so the appeal backlog about a year ago was running a little bit over, it's around 4,000 appeals. I understand now the number of appeals in inventory, if you will, is under 3,000. I have been led to understand. So basically, the workload of the board has been shrinking. We did a big effort, just by the way, last year, as was announced. There was a goal for the board to reach a 12-month, absolute time from docketing to disposition for appeals. We made it through hard effort of folks like Vice Chief Judge Mike Kim, who was the principal driver of that effort. But everybody pitched in, got behind it. And at the end of the fiscal year, the goal was achieved. So the appeals, not only in terms of the numbers, but the time to getting a decision, are way down. Interestingly, though, as I've talked to folks, even though appeals are now very rapid, not everybody knows that the pendency is under a year. Some folks still think it's 2 to 3 years. It isn't, although back, and Terry remembers this well, the dawn of the AIA, there actually was a huge problem with the appeals inventory. It was approaching 27,000 appeals. The pendency was 2 years or more. And through a lot of hard work and effort, that problem disappeared. I mean, that problem's not been a problem for many, many years. And now the appeal situations, frankly, is as good as it's ever been. However, maybe to Jackie's point about fears of rifts, it's never a good thing to run out of work, either in private practice or in the government. So, if the work dries up completely, that could have further consequences to the workforce.
Scott, you mentioned that the number of IPR filings is down to approximately 40 from 120. We're also seeing that the number of institutions is down, and therefore we're going to have fewer trials. Does that have an impact on workload?
Well, absolutely. And, something we haven't gotten into yet is, the major changes in the way that AIA trials are instituted, and sort of gone through 2 steps. The first step was that, the deputy director, when she was acting director, took over the the institution process, at least in terms of discretion only. And then the merits was still left with board panels. And the director, when he came on board, took over the entire institution process. So the board, other than supplying staff judges, if you will, to the front office, really has no role in institution anymore, which is a total change from the way that the trials had run. And you're right, the numbers are way down, as I'm sure we'll get into. The explanations have been getting shorter and shorter. The deputy director supplied a very terse explanation, but at least there were a few words of explanation of why discretion was being applied. And right now, you just kind of get a thumbs up or a thumbs down with a super terse explanation that doesn't really give anybody any predictability or understanding of the reasons so they could modify their behavior. Although, again, now, and we'll probably get into this as well, but there have been decisions of the board designated as precedential or informative. I'll note that those decisions don't bind the director, who could choose to change his mind at any time for any reason. So the lack of predictability is, I think, a factor in why you see the filings dropping off, because they're very expensive. You know, they're less than a district court action, but they're not cheap. And I think clients, I've been told, are increasingly wary as the predictability has evaporated to decide to put their money in a filing when you can basically roll a dice and, you know, have about the same ability. So anyway, that's.
Sorry,
Yeah.
Scott.
Yeah.
If it's all right with you, I was going to use this to present some stats that we had put together for purposes of this presentation.
Sounds great.
One of them was basically the outcomes of the director's decisions on institutions since October 20th. October 20th is when Director Squires, a few days before, they issued a memo that effective October 20th, that he on his own would decide all aspects of institution decision, not only the discretionary denials, but also the merits. And so to look at what those outcomes have been since October 20th through actually 2 days ago, we've seen that about 50% are discretionary denial, about 5% are denied on the merits, about 35 are what we call referred. That means they have made it through the gauntlet of a discretionary denial, but now they're going to be assessed on the merits, so that's not an outcome yet. And about 11% have been instituted. Another way to look at the stats is the institution rate by calendar year. So for example, in 2024, as many people know, the institution rate was about 2/3. In 2025, overall, for the whole calendar year, it was about 44%. And in 2026 so far, and granted we're a month in, but it's at 21%. And one thing that is interesting too is to look at what the institution rates are by technology. And for these numbers, this is since March 26, 2025. This is when the bifurcated process started. So this includes the bifurcated process where the deputy director determined the discretionary denials and the panel still did the merits, and plus the new proceedings now under the October 20th memo. And what we've seen, the institution rates overall since March 26 overall is about 36%. It turns out in the electrical space, it's about 29%. In the mechanical and business method areas, it's higher, it's at 44%. And in the biopharm and chemical space, it's 56%. So it does seem to be that there are slightly notably different institution rates depending on the technology that's being challenged. I will notice that actually petition filings, as Scott mentioned, has gone down. In December, my understanding is that, sorry, normally I have slides for these. I see somebody says that I'm going fast. So I can repeat those if somebody would like me to, but I will just say that the filings, the AIA filings in December were down. They were in December, they were about 35, and in January so far, they're about 45. In the past, we've seen between 80 and 120 a month. So it has dropped pretty dramatically. One interesting thing is what has happened in ex parte re-exams since then. Because in October, it turns out that the filings of ex parte re-exams surpassed the filing numbers of AIA petitions. And it's pretty much stayed that way since. So, for example, ex parte re-exam petition requests were over 100 in December, and they're about 70 so far in January. So you can see that basically before that, we saw about less than 40 ex parte re-exam requests per month, and AIA petitions were closer to 100 per month. And so now that has seemed to shift to go the other direction. If I can also see about putting those numbers, and I'll put them in the chat. I think that's the best way to handle that. I also wanted to just flag, because we're talking about workload issues, is that some of the incentives to leave the office hasn't just impacted PTAB, it's also impacted the CRU. My understanding, and people can correct me if I'm wrong, but my understanding is that in the beginning of January 2025, the CRU had about 70 examiners, what they're called specialists, and 6 SPEs. My understanding today is they have less than 50 examiners with 5 SPEs. So this is a situation where the workload of the CRU is dramatically increasing, and their workforce, if you will, to address it has actually been lowered. So it is going to, I think the CRU is going to have their work cut out for them. So we'll stay tuned on that.
So there was a time, Terry, when you were in charge of it all, and you had to make sure everyone was happy at the office. And you and I are former colleagues, and I know lawyers don't like change. You know that as well. What do you see as, all these changes and the impact on morale at the office, and in particular at the PTAB? You're on mute, Terry.
I still think of you and I as colleagues, just to say, Todd, just because we worked together for so very long. So I'd like to take a step back to the last presentation, Deputy Director Stewart, when she mentioned the cafeteria at the PTO. And that was the epicenter of culture. That was the PTO culture, examiner culture. It was tough to find a table. So I ate in my office. I was forced to eat in my office frequently just because there was nowhere to sit. And people from other places, other agencies, I think Director Stewart also mentioned that. So people would come and use our facility, and I'd frequently be there, and I'd see from next door the Article 3 judges and the magistrate judges in our cafeteria. And of course, I'm a busy person, I'm walking fast, but if I see someone I know, I'm going to say something. And I usually would say, "Hey, what are you doing in my house?" Because why were they coming to the cafeteria? They said it kept them energized, they kept it vibrant, they kept them focused. They liked the vibrancy of the cafeteria and the PTO, and we had great salads, and it wasn't a heavy meal, so they could stay awake for their jury trials in the afternoon. But it was a fabulous, fabulous culture. And when I was there, the Partnership for Public Service is a public-private partnership that has all employees in the government take a survey and say if they're what they think of the agency that they work for. And when I was there, the survey they took, you guys, I don't know if you remember this, but our agency was #1. And that's the only time the PTO was #1. So I got to live be at the PTO during the good years when everyone was happy. And it's not so much, it doesn't have the same level of relaxation and comfort and collegiality that it once had. And examiners seem to think that the change, as you mentioned, Todd, is moving too fast, and perhaps a pause and thinking things through and communicating them would be helpful to the examiner, since it's their career, their life, and their family that are on the line with their job. So morale is not particularly high right now. As a matter of fact, it's pretty bad. A lot of employees at the PTO, not just PTAB judges, feel underappreciated. Probably the one story or the one individual I talked to that just struck a chord in me the most was actually a female who trying to get that work-life balance thing. She and her husband sold a car. They were down to one car. She could work from home. She had daycare such that she could pick up, she had daycare where the daycare provider, you had to leave the kids off later and pick them up earlier, but it worked for her when you're working from home. And the change and the return to office completely put her entire life in upheaval. She had to buy a new car, which was unfortunate, and economically stressful. She had to completely change her two daycare providers for her two children. She needed somebody who did the very early hours to the very late hours. So the upheaval in the lives of not just judges, but to those at the PTAB was like tremendous. The biggest concern I think Jackie went through was job security, the concern of demotions, the concern of rifts, the uncertainty. I've worked in corporations and several law firms, and I've never felt like I had that lack of job security before. But right now in the PTO, it's palpable, and so palpable that that Partnership for Public Service, from what I understand, did not even send the survey around last year because morale, not just within the PTO, but within many other areas of government, were not particularly high, and they'd like to have thought that was not a valid survey. But right now, the stress at the PTO, if you go to the National Inventors Hall of Fame, if you talk to any examiners, they're all under undue stress and concern for jobs. And what does this have to do with the PTAB? I think that happiness, collegiality, job security, enjoying where you work, it's all extremely important to your output and what you do. If you're not contented with your job, the quality of your work perhaps will not be at its highest. And I am losing my voice, and I apologize to all of you right now. And if anybody else would like to chime in, please do so.
I'll just answer the question, what does this have to do with PTAB? It's affecting the entirety of the USPTO, so it is affecting PTAB as well. And I do think that, many people have recognized that morale is important both for recruiting and retention and to make sure that people, a lot of people, and it's certainly true at the PTO, go well above and beyond the job. They work very, very hard and they do it at a significant cut in pay. And just when you don't feel good at work for whatever reason that is, it does have an impact. It has an impact on your ability to produce. It has the ability on, I think that at the PTAB, the judges will always put quality first. They will always maintain that. But I think it becomes harder and incentivizes really good talent to leave. So I think that's why, again, it is not just to a PTAB, it's throughout the entire agency. And it's just, the morale problem, it really is something I think that I'm hoping that will be addressed in the future because it's pretty significant from what I've heard from everybody.
I'll just echo Terry and Jackie's comments in that it's related to the talent drain. It's related to burnout and other issues for people there. So and it's not just the PTAB, it's the entire agency. I can tell you from people that I've talked to across the agency, this is a universal problem right now at USPTO, and frankly, I think it's a very serious one. So that's all I'll say.
I'm going to turn to another topic and get Mike speaking here. When AIA came out, I think it became much more popular than anyone really expected. And the PTAB received a lot of criticism as being a death squad and things like that. And we'll talk about the criticisms later. But as I saw things over time occur, we had Director Yanku come in and he maybe pushed that pendulum more in favor of patent owners. And then we had Director Vidal come in and maybe push that pendulum back a bit. And now we have Director Squires in, and it appears that pendulum is being pushed way in favor of patent owners now. And I just want to get your sense of the influence of the administration on PTAB proceedings.
Sure. I mean, let's face it, that's the point of having an executive branch where you vote for a president and they appoint Secretary of Commerce, they appoint the director of the agency. They're all going to come in, and you see it every time. They're going to come in with a purpose. They have a mission, they have an idea of what they want to accomplish. And so going back, I've worked for a lot of different administrations. Everyone came into the office with a certain mindset of what they were hoping to accomplish, and they wanted to hit the ground running. So some people wanted to move a needle a certain direction. For example, Michelle Lee, she wanted to be the best place to work, and she was very engaged in trying to get there's a survey conducted about for government employees, is this a place you want to work? She wanted to be the best place in the government. She was taking steps to focus on that. We've had other focuses that are specific to PTAB, as you know. Capos was brought in. Back when we had the TAFAS decision, one of the first things he did was make sure he settled TAFAS. When he had the PTAB, he wanted to have outreach, all right? He was trying to make sure that the public was engaged. He wanted to try and find I'll say a middle ground. You'd have to ask him exactly what he was trying to calibrate to. But in my mind, I took it as he had different viewpoints. He wanted to hear them all, and he wanted to find a path through it that he could no one was going to be 100% happy. But then again, no one was going to be 100% upset. They could all find something in there. And you see that each director comes in with their own view of what that middle ground should be and what that direction should be. So administrations will change the needle and change policies. Some will say it's more favoring the patent owner. Some will say it's more favoring a petitioner. But everyone has their ultimate ideal. Now, the current administration has their own views on how to move the needle, and they're actually very strong viewpoints, shall we say. And they have, for example, settled expectations and all. But I will say, even with this administration, when it comes down to it, is the claim once you get past the discretionary denial hurdles, you still have the same board and the same decisions being made. Is the claim patentable or not patentable? And they're still issuing quality decisions on that aspect. So I think that's a truism for every administration, which is they want to get the decision right in the end. No one wants to send the final written decision out where the decision on patentability is incorrect. Again, they're trying to achieve high quality work products. So in that sense, the needle there on quality work products stays the same. The discretionary denials will vary with administrations. And I do want to point out just quickly, I know I've made a couple minor things. I said 4173 for inter-party re-exam was a do loop. It was 4177. Someone pointed out that there's still 2 inter-party re-exams. I think they could go another 4.5 years. I'll just put out my personal statement. I'm really hopeful that they finish them up this year and we don't go to the 19 years. We can finish them at the 13 plus year range. Also get my American Association of Patent Judges, get that out there. Again, if anybody wants to know the history of the board, please go to American Association of Patent Judges. It's a great website, and they have a full-blown history of the board there for you to look at.
And I was just going to add one thing. When the AIA was implemented, and got into full swing in 2013, the office asked for and received a lot of really important feedback about how the proceedings were going. And I know there were some serious efforts starting in 2017 through 2024 that were intended to address, stakeholders' concerns about abuse and fairness in the process. There was a lot of work over those 8 years. They had been working on discretionary denials. They vamped up the motion to amend process, and all of it, the intent behind it was to be fair and balanced and transparent to all parties and stakeholders that are impacted by these proceedings, and to be consistent with the AIA and the law generally after receiving feedback from the public. For example, when we were working with Andre Yanku, there were 4 major areas that were addressed at that time. It was serial petitions. These are ones that are filed later in time. For example, General Plastic was and Valve was designated precedential. Parallel petitions, those are filed around, more than one filed around the same time. There was some guidance in the trial practice guide. There was parallel proceedings between the PTAB and the district court and ITC. So the infamous, fintive jurisprudence. And then, of course, there was some good clarification on 325D. This is when the same or substantially the same prior arguments are previously presented before the office. There was put together back then Advanced Bionics and Beck and Dickinson precedent to address when 325D is implemented. And so a lot of work was put in place beforehand precisely to do that. I just want to remind everyone that a lot of work and thought went into it under multiple administrations, under multiple parties, to try to address a lot of the concerns that people have raised.
Staying on that, I want to turn to the next topic, and that is, there's been a lot of criticism of the PTAB over the years, and a lot of it's focused on historic high institution rates, high success rates at final written decision, too many parallel petitions. We've heard that the PTAB was really focused on finding patent claims unpatentable. There was a culture of that. Were those criticisms fair? Jackie, maybe you can continue.
Sure. I do want to clarify, to the extent there's any misconception, because it's really important. And we've heard it before, some of this misconception. I mean, the APJs understand their job. They understand the law, and they have always understood that their job has been to, it's not to find claims unpatentable, it's to adjudicate whether on the issue of patentability. So they understood that their job has always been to determine whether the arguments, the briefing by both sides, the facts, the evidence of the law, has indicated that the petitioner has met its burden to show claims are unpatentable or enough to go forward with the trial in the first place. The judges, I mean, I worked at the board for many years, as did Mike and Scott, of course, and it has never been the case that the judges had some preconceived notion of an outcome or understood that their job was to find claims unpatentable. It is also the case, because it's required under the law, and they would be reversed or otherwise seen as not doing their job properly if they ever place the burden on patent owners. It is under the American Invents Act. It's the burden for the petitioner to show that it has a reasonable likelihood in order to go forward with the trial. And it is also the burden on petitioners to show unpatentability. And that's what the judges do. They adjudicate whether the petitioner has met their burden. And I wanted to, and actually this was in the comments, so I want to address that. We still hear the inaccurate assumptions that PTAB has canceled 80% of the patents that are challenged. This has never been correct if you really understand how they work. I mean, first of all, as a baseline, it's important to understand that the vast majority of patents that are live out there are not even challenged at PTAB or in district court at all. So that's really important. It's an extremely small percentage of a fraction are even at issue in an AIA proceedings. And the other thing is that it's important to note that there's a selection process that occurs whether a petition is even filed in the first place. It is, as Scott mentioned, it's a lot cheaper than district court litigation, but it's still expensive and creates litigation risk if a petitioner files a petition and something doesn't go their way, either at the institution stage or at the claim construction or what have you at any point. So generally, petitioners don't file unless they think that they're going to win, for example, and specifically on the merits. So for example, people talk about in the past about 80% of IPRs had co-pending district court litigation. It turns out the reverse isn't true. Third-party data has indicated that about 20 to 30% at most of the patents in district court actually are challenged in an AIA proceeding. And what that says is that defendants are strategic in what they do. Like I said, there's a selection process at that stage. And then, of course, there's another selection process at the institution stage So it turns out that only about a third of petitions even make it to the final written decision stage at all, where they determine whether the petitioners met their burden under the preponderance of the evidence standard. And it turns out that with all of that in mind, about 70% of the challenged patents don't result in any claim being held unpatentable by PTAB in a final written decision. And it's a very, very small percentage. It's about 10% of them result in all of the claims basically invalidating the entire patent. So I think it's important to understand those stats. I think people have over the years, sort of cited them incorrectly, looking only at what happens at the final written decision stage without understanding the selection process that happens along the way. And so that's really important to understand.
Scott, Mike, you want to chime in on this?
Well, I saw there was a question about the number of large ex parte re-exams being filed and what's going to be done about it. And just point out, I did retire at the end of last month, so my knowledge is maybe out of date by a month. But I was on detail to the CRU to help out for the last 4 months of my career. And one of the things we were looking at very seriously is trying to find ways to help out the CRU examiners, the specialists there. They have a great group of people who are doing a fantastic job working there, but they do need additional resources. And it was something that we knew, we were bringing it up the management chain. But if you look step back, a lot of people in the patent group also need help. I mean, they're hiring examiners as we speak. So there's a resource allocation going on right now and trying to get additional resources for the examination in the CRU was one of the top topics at the PTO. And so it's something the agency is aware of, and they're actively, at least we're actively looking to try and bring them the additional resources to help them out.
So I want to turn next to what I see is a big problem. And that is, we talked about changes from administration to administration. And whether you're on patent owner side or you're on petitioner side, and you're representing clients, you want to be able to give your clients advice. And I may give advice today, and we have a change of administration in the future, and the advice I give today might not be the best advice. But it was good advice at the time I gave it. And Scott, maybe we start with you and my concern about a lack of predictability and maybe ultimately transparency. How do we solve that?
Yeah, thanks, Todd. And I agree. At least, my personal perception right now is that there needs to be more transparency and more predictability. As I mentioned before, it's a little hard for me to read the tea leaves because, again, some PTAB decisions were made precedential, but as we all know right now, precedential decisions only bind the board, they don't bind the director. And so you have precedential decisions binding the board on issues they no longer decide. So maybe those are tea leaves or hints, if you will, but they're certainly not binding. And there have been episodes recently of the board holding a webinar, giving information, then things change. And parties relied on the information that was in the webinar. Again, I think that what would be very helpful is for there to be definitive guidance from the director, either in the form of director memos or rulemaking. I know there is a rule package, out there, which is the process that's normally been followed, to have public input and put things in rules. But when rules are not always followed, without going through the process of retracting those rules, just ignoring them, if you will, I think that's problematic and creates a lot of uncertainty about, well, what to do with this now. Again, I'm hoping that the uncertainty was unintentional, but there are steps, and I think the steps are for the director to put out guidance to say what the director is going to do and why, and when the director makes a decision to actually explain it. I think that much would be very helpful in creating more predictability and perception, because these, are expensive proceedings, and they're not as, again, not as much as district court, but they're not cheap. And I think that would really help parties to understand what's really going on. Again, my personal view. And Todd, I think you're on mute.
Anyone else want to chime in on this?
I will just say that in the past, the way to create transparency and consistency, at the board and frankly at the office has been through the statutes, the rules, precedent, informative decision, and in guidance, director memos, the trial practice guide. And the advantage of precedent and guidance is that they can happen fast. And so I will say that the recent designation of precedential informative decisions, regardless of what you think about them, it actually is really good that that's out there, because it does. And while Scott points out that the director, I think the director is bound by them, or at least in theoretically will follow them until that person says otherwise. And I also think it's important that people understand the rules of the road. And so when information is shared with the public so they even know what to do and how to make business decisions, I think it's really critical. So I do commend the office for making some cases precedential and providing guidance about what is going on, what the rules of the road are. I will say, though, that when things change so rapidly, that comes as a surprise to people, and it really makes them flat-footed, and means that they've made business decisions based on information that's no longer valid. That's very tricky, and so having more stability there is really helpful, and that obviously is helpful if it's done by statute. So I know that people have, if people have proposals about what to change in the AIA, that, obviously that's a great way to go. Rules is probably the next best, not least of which, because it generally requires notice and comment rulemaking. So you actually do hear from the stakeholders, and that there can be some thoughtfulness behind that. So that can be really helpful, just to help provide certainty where we can.
Anyone else?
We do have a question asking for what are the 5 most common mistakes for patent owners to make, and how can they change the outcome? I know, Jackie, we've talked about that many times when we're at the board. Do you want to maybe kind of give some tips, or you want me to start, or Scott to start?
I think some of Mike, you by all means can go first, but I think, the burden is on petitioner in these cases, and the judges know that. But it's helpful when patent owners explain why they haven't met their burden. And in things like obviousness, to really not be conclusory on things like secondary considerations and stuff like that. And to make sure that and this is advice for all parties. When you have experts and you rely on them for certain things, make sure those aren't conclusory. Make sure that they have basis for what they say, and just make sure that the arguments are well done. That you explain yourself. Again, this is for all parties. Explain yourself well. Cite evidence and support. Anything that's conclusory is probably going to not be given much weight. And I think and pick your battles, so to speak. I think sometimes people try to argue too much, and then they end up short shrifting what they intend to be important arguments. So that's probably the biggest one, and that's not specific to patent owners. That's for all parties who appear before us.
So my quick points would back up yours, but basically the burden is on the petitioner. So look for any weakness you can, and then drive it home as hard as you can. I never really appreciated the shotgun approach, because then it was very much a light touch. It didn't get into the details, didn't have the evidentiary backing necessary to show that petitioner hadn't met its burden. So pick your battles, you say, focus in on, and the key issues I always thought, one, reason to combine, because most of the time we're dealing with obviousness, right? So focus on the obviousness, show why there's no reason to combine. Also, go after claim construction. Quite often, the claim construction may be a weakness. The petitioner sometimes will lump elements together, and if you can show that one of the elements that's required is missing, all the better. So get your evidence to support yourself. And lastly, just a shout out, and Jackie, this is something near and dear to you, amend your claims where appropriate.
We're close to the end of our hour, and I'm going to give everyone a chance to give their final thoughts. I'll start with you, Terry.
Well, one of my issues that we didn't quite get to, so maybe I'll just address that, is are we on the right track? And that's something we will only know down the road. Did we increase innovation? Did we take the cost down? Did we increase predictability so that corporations could make better informed decisions? Because the PTO doesn't exist just to keep people employed. It is the innovation agency. So will we stay number one in the world in terms of innovation, cutting edge projects, cutting edge issues, cutting edge technology? I mean, in terms of software, computers, biotechnology, I mean, we were fabulous. Now in this day and age of AI, I don't know if our edge is going to be more difficult to maintain, but we'll only know in retrospect whether or not we're on the right track if innovation is, continues along the great path that we've historically had.
Scott, final word?
Yeah, maybe picking up on what Terry said, right. It's unknown. There are a lot of policy choices that are possible. I think where you see differences, I think you still have a common desire of everybody for the US to be the leader in technology, to be number one. That's what we all want. We may not all agree on how to get there. One thing we didn't touch on, and we sort of ran out of time, is the role of Congress. There is some pending, legislation that's been introduced that makes even some different choices than the administration has made, but it remains unknown at the moment of, well, what is the sense of Congress, on this, and what direction, do they want? So I'll just leave that there, but I think that's an important piece of the puzzle as well.
Mike, last word?
I just want to thank the panel for having me today, and everybody in the public for coming in and listening. It's been a really good panel, and I appreciate it. So thank you.
Jackie?
Yeah, no, I want to thank everybody for being involved. It's really great to hear the different viewpoints, and I'm looking forward to the panels later. I think my last point would be, I think everybody agrees that when things are fair and balanced and transparent to everybody impacted by these proceedings, and at the USPTO at large, that's when the patent system works to stimulate innovation. And I think having the debate about where that perfect Goldilocks place is, I think is worth having. And I think that it's important for people to talk about that. They can submit, they can reach out to the USPTO to provide their comments. They can certainly reach out to members of Congress and the senators and the like to talk about that. I think it's important that all voices are heard and that it's very thoughtful when we go through, when whoever makes a decision, because if it's off balance, that's when it starts to deter innovation. So it's really, really important to get that right. And I know everybody is trying to, and got to make some good decisions on that.
Well, I want to thank all of you for your dedication to public service. For some of you, I got to argue cases before you many times. It was not always fun, but it was always fun. And thank you for being part of the panel. I look forward to interacting with you going forward. I also want to thank IP Watchdog, Gene and Renee. This has been a great panel.
Great. Well, thank you very much, Todd. I really appreciate you moderating this panel, and I appreciate all of you panelists being here as well. And I obviously appreciate the support we have in the community with everybody in attendance. Thank you so much. We'll have a second judges panel coming up here at 11:45 a.m. We'll pick up on some of the questions that left unanswered, and I wrote down the one that Terry left us there at the end. Are we heading in the right direction? Are we on the right path? And maybe we'll kick off the next panel with that question. So thank you all, and that's all we have for this segment. We'll see you at 11:45 a.m.
Thank you, everyone.
Thank you.